If you ride a motorcycle in California, the same DUI law that applies to car drivers applies to you. Vehicle Code 23152 makes it illegal to operate any motor vehicle with a blood alcohol concentration of 0.08% or higher, or while impaired by alcohol or drugs. A motorcycle is absolutely a motor vehicle under that definition. There is no special exception because you are on two wheels. Field sobriety tests designed for car drivers do not always translate well to motorcyclists. Officers are trained to look for different cues when pulling over a rider: weaving within the lane, trouble with the kickstand, difficulty with balance during the stop, and slurred speech. The National Highway Traffic Safety Administration has its own motorcycle-specific indicators of impairment, and California officers use those alongside the standard tests. Because balance is already a skill required for riding, some standard tests like the one-leg stand are considered less reliable for riders. California requires all motorcycle riders and passengers to wear a helmet, and that law is separate from DUI law entirely. If an officer stops you for a helmet violation and then notices signs of impairment, that can lead to a DUI investigation. Also, California's open container law applies to motorcycles. Alcohol in an open container cannot legally be within reach of the rider. A first-offense motorcycle DUI carries the same core penalties as a first-offense car DUI: license suspension, a base fine of several $100s that mandatory penalty assessments multiply several times over, DUI school, and probation typically running 3 to 5 years. A conviction can also affect your motorcycle endorsement specifically. On a first offense with no injury, an ignition interlock device is generally a choice, not a requirement. You can install one for roughly 6 months to keep full driving privileges, or accept a more limited restricted license without one. Results vary depending on the facts of your case. A DUI conviction shows on the DMV's public driving record for 10 years. After that 10-year window, it no longer appears on the record employers and insurance companies typically see. However, the DMV maintains an internal record that does not go away. That internal record can be pulled on a transcript request, and it counts as a prior conviction if you are ever arrested for a DUI again in the future. Because motorcycle field sobriety tests are less standardized, there may be questions about whether the officer's observations were accurate. Chemical test results can also be challenged if proper procedures under Title 17 of the California Code of Regulations were not followed. Title 17 sets rules for how blood and breath tests must be collected, stored, and analyzed. If those procedures were not followed correctly, the reliability of the result can be questioned. Every case turns on its own facts, and results vary. Riding a motorcycle does not change your exposure to California DUI law, but it does create some unique factors worth understanding. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.